Okay, great. I think we are now on, and I am Delegate Charlotte Crutchfield, and I am the chair of the Family and Juvenile Law Subcommittee that is meeting today, which is Monday, February the 24th, and we have several bills to take up. And what I'd like to do is go ahead and start with HB 236, which is Delegate Valentine's bill. Delegate Valentine, if you will walk us through your bill, I know you have some amendments, but if you could give us kind of the abbreviated version, and then also walk us through the amendments and how those apply, and just let us know if there's anything else you need to add.
Well, thank you, Madam Chair, and thank you, colleagues. This is the intentional surveillance, video surveillance bill that I brought last year, then again this year, and we made some changes from last year to this year, and I have some additional amendments to conform to the Senate's version as well this year. So last year, we received feedback from the judiciary that said the wording in our bill last year was very open-ended. It was very broad, and they also felt that some of the relief that would be granted in these type of cases, they did not have the statutory authority to implement should a peace order be issued if someone's neighbor was videotaping them. So we met with them, we met my senator, Senator Quarterman, and I, and we brought this year's bill to make it an intentional video surveillance or visual surveillance. We also implemented some of the relief that the judiciary had requested. After our hearing, and some of the colleagues of our colleagues in the judiciary this year also felt that intentional was somewhat vague and it could be misinterpreted or open to interpretation, in other words. So what the Senate did in JPR, they work grouped this bill and thought it would be a better route to, instead of separating intentional video surveillance or visual surveillance, thought it would be a better idea to embed this type of a case into the already existing harassment statute. So let me explain what the amendment does. Right now, in the criminal law article, harassment is defined as a person may not follow another in or about a public place or maliciously engage in a course of conduct that alarms or seriously annoys another. And then there's several steps after that that have to apply for that statute. The amendment simply makes conduct visual surveillance in an area of another's residence where that individual has a reasonable expectation of privacy as one of those categories, along with following people to annoy or engaging in a course of conduct. So it's just an or. So it's one more element or one more way of harassing someone. The important part in this is there's four things that need to apply for it to be harassment. Okay. It has to have the intent to harm, harass, or annoy. You have to receive a reasonable warning or request to stop. The person has to request them to stop or someone on their behalf. And also it has to be without a legal purpose. And last but not least, it says the section does not apply to peaceable activity intended to express a political view. So in other words, in the person who testified, my constituent, what they would have to show is their neighbors surveilling them with video surveillance, and it's annoying her, harassing them, which it was. They had asked them to stop, which they did and did not stop. There was no legal purpose. And I think that was brought up a good point by Delegate Conway last year's was, could we show that the neighbor put up a camera because they thought maybe the person's neighbors were, or their animals were getting out or something along that. So there might have been a legal purpose. That could be like for your ring cameras on your front of your house. You know, you have a legal purpose. You want to monitor your property. But I think in the situation of my constituents showed that there wasn't that legal purpose because they put up a barrier and they raised it up higher. So their purpose was specific to annoy, harass, and alarm my constituent. And last, let's see, it doesn't, the gentleman wasn't expressing a political view or providing information to others. So what we basically did was we put this type of surveillance in a harassment statute and then have guardrails that shows that an individual has to meet all of these thresholds for it to be harassment. And I would certainly answer any questions that you might have about that.
Okay. All right, I see Delegate Taylor has a question. Go ahead, Delegate Taylor.
I do. Thank you, Delegate Valentine. Thank you, Madam Chair. I believe I read somewhere that if it is considered harassment, then the harasser had the option of removing the camera, or would be asked to remove or reposition. Yeah, I'm seeing it now. Reposition the device.
Yes.
Repositioning the device kind of gives me a little, because they did that. They repositioned their device a couple of times, right? Higher and higher, right?
Well, the repositioning part, it would be by a judge after a hearing. So, and what it might be in the circumstance I'm looking at is, okay, maybe back down to ground level where it's not directly looking at, you say, yourself or your kids. Or the judge would also have the option of ordering the removal altogether.
I see. So the judge would determine where the reposition would be.
Correct. That's the part of the relief.
Okay.
If it's found that the person is actually committing a harassment with this visual surveillance, a judge at a hearing would then decide if the camera should be taken down or moved to a position where it would not be harassing the individual.
And I believe that's part of the judiciary's request to be given the authority to do that, correct?
That is correct. When we spoke with the judiciary under the sections already in statute, they didn't feel they had the authority under existing statute for the other visual surveillance sections. So they asked us to include that so that would take care of other parts of the statute as well.
Okay. Any other questions? Everybody, okay. Delegate Simmons.
Thank you, Madam Chair. I just want to know, does this bill have a fiscal note? I didn't see it in my paperwork I have here.
Stand by 1 second. Let me look.
It's 29,600.
Thank you.
You're welcome.
And as for programming changes, do you have any idea of what those are, Delegate Valentine?
I'm sure to update the forms and in the computer system would be for, because every time with the petitions and whatnot, a programming change would require them to change the forms with the statute as well as the different options for relief.
Move the amendment, Madam Chair.
Do I have a second on the amendment?
Second.
Madam
Yes,
Chair, can
go
I say
ahead,
one
sorry.
more thing? I'm sorry if I could say one more thing.
Yes.
The amendments conform to the Senate's version, which did pass out of the JPR unanimous as well as the Senate unanimously as well.
Okay.
And this amendment just conforms so they're identical.
Got it. Got it. All right, I heard a second on the amendment. Let's vote on the amendment. Just raise your hands. If everyone's in favor, okay, looks like we are unanimous on being in favor. All right, any more discussion on the amendment? Okay, seeing none. Do I have a motion on the bill?
So move, Madam Chair.
All right, do I have a second? Okay. All right, and Delegate Simmons, your hand is still up, so
Oh, okay, my bad. I'm sorry.
just want to make sure we captured the
Yep, you
vote
got it.
correctly.
Yeah.
All right, and let's just go ahead with a roll call vote on the bill. So Delegate Boucher.
Yes, ma'am.
All right, Delegate Kaufman.
Yes.
Delegate Pastor is excused. Delegate Sample Hughes.
Yes.
Delegate Simmons.
Yes.
Delegate Simpson.
Yes.
Delegate Taylor.
Yes.
Delegate Tomlinson.
Yes.
And Delegate Valentine.
Yes.
And that'll be yes also for me. Great. All right. We're going to move on to our next bill, which is HB 442. And Delegate Simpson, would you please lead us in discussion on that? if you'll just start out with a general understanding of the bill, let us know if there are any amendments. I didn't see any. And then we will take it from there. So if you'll just start out with a general discussion overview of what the bill does.
So there are no amendments. This was a request from Frederick County. It was, basically saying that this, by adding this forensic interviewer, which would be a trained forensic interviewer, which, I used to be years and years ago, would, of course, it doesn't mean that kids wouldn't have to, testify in court, but it does add that extra layer. So it just, and it's not just for Frederick County, it is for statewide.
Okay. And did they mention sort of when this comes into play other than, I guess it's during any time that there's a child victim or witness?
Yeah, whenever there would be a child or actual vulnerable victim, but mostly the goal was for child welfare.
Okay. All right. And I know I only saw one unfavorable on this, and this was the public defender's office. Do you know what their concerns were, and have you addressed or discussed those with them?
Yeah, their concern was they don't want to add anybody else. They think that it could end up being, opening it, which is not the case. They talked about child welfare workers, which it used to be until, they narrowed the scope of who could be in child welfare, which, to social workers. So.
Yeah, and they talked a bit about the child in need of assistance cases in particular.
Correct.
So, okay. Let me see, what did they say?
Are they here?
No, they are not here. They are not here. Okay. All right, so I will open it up to any other questions. Are there any other questions on the bill?
Move favorable.
Okay.
Second.
All right. We will then take a roll call vote on the bill. All right, Delegate Boucher,
Yes, ma'am.
Delegate Kaufman,
Yes.
Delegate she's excused, sorry. Delegate Sample Hughes,
Yes.
Delegate Simmons,
Yes.
Delegate Simpson,
Yes.
Delegate Taylor,
Yes.
Delegate Tomlinson,
Yes.
Delegate Valentine,
Yes.
and I am a yes as well. So that bill has passed out of the subcommittee as well. All right. I'm going to also now go to HB 542, which actually is my bill, which is really kind of odd for me to do this. But anyway, it has no amendments to it. And basically what it does is it allows for the authorities between the different counties dealing with DHS to be able to get more information from the feds. For example, the state's attorney would now be able to get information if there was a vulnerable adult in a situation where there is a postal fraud issue. They can now go to the inspector general, have those authorities, because currently they don't feel as though they actually have authority to go and get information from federal agencies. So that's really what this bill does. Are there any questions? Yes, Delegate Valentine.
Thank you, Madam Chair. I think you just answered my question because I have in my notes, why doesn't this happen now? Do they just simply, are the local agencies think they can't? Is there a reason why they just don't do it? I mean, I think you explained it.
Yeah, so what happened is my county attorney mentioned that they they go and they through collaborative effort try to get information. but they really just don't have the authority to just say, listen, now we're coming to you to get information, but they try to work it out. They try to, and then it takes a longer period of time as well. So they want to
Okay.
really, I think, put together a process and make it clear they have authority. And then, for both of the federal and the state and the, local entities be able to work together that way.
Now, they haven't been receiving pushback, have they? From
No, they
the
have
other
not.
one?
It's
Okay,
not that much. I think it's been a slower process.
okay.
But yeah, I was not hearing that there was a lot of pushback. It's just
Okay.
that it's a slower process. And when you get to these issues with, older adults, vulnerable adults, period, you want to speed up the process and get it done so it can get to the state's attorney's office and they
Right.
have the right information. So that's really what it's about. So this bill also had a cross file that, believe it or not, it was voted out of JPR. And I thought I just saw that it was actually voted out of the Senate. And Lauren, do you have that by chance? Was it, I'm gonna say it was.
I can check.
Madam
Okay,
Chair, I have it 45-0 out of the Senate.
yes, got it. So it is coming our way.
Awesome. Move favorable.
All right, do we have a
Second,
All right,
Second.
great. All right, we're gonna do a roll call vote then. Delegate Boucher,
Yes, ma'am.
all right, Delegate Kaufman,
Yes.
Delegate Sample Hughes,
Yes.
Delegate Simmons,
Yes.
Delegate Simpson,
Yes.
Delegate Taylor,
yes.
Delegate Tomlinson,
Yes.
and Delegate Valentine,
Yes.
and myself a yes. Okay.
I'm glad you voted
Wow.
for your own bill, Madam Chair.
Yeah, I better vote for my own bill, right? Thank you for acknowledging that. All right. Can we get in the room with us, Delegate McComas? Is she here by chance? Because we want to go to HB 1209.
Here she comes.
Okay, great. Thank you. All right, and while we're waiting, so we're going to go to Delegate McComas's bill 1209. And okay. Oops, it's taking her a while to get in here. Okay. All right. While she's getting in, I think what I'll do is just kind of try to start things off. So this is about okay, there she is. All right, Delegate McComas. Delegate McComas, I see you're in the room.
Perhaps she's on mute, Madam Chair.
Oh, she is on mute. So that's why I'm trying to. Delegate McComas. Okay, because she just contacted my office and said she couldn't get on. Let me see.
Oh my goodness.
There you are.
Yeah, I was waiting. I started before 10 and I'm like, oh my God, I can't get on again. So I called your office. So if I missed anything,
No. We just called your bill. I just called your bill.
Oh, okay.
All right. And so what I'd like to do is ask for you to explain your bill to us. Just a short overview of it. And then if there are any amendments, and I do believe you do have an amendment. But anyway, if you'll go ahead and just give us an overview of the bill and what it does.
All right. The bill is the genesis from the child custody group that was formed over 10 years ago. And Delegate Dumais, now Judge Dumais, and myself were on that group, as well as they had psychologists, a really very inclusive group of people. We had folks that were the men's organization, that may have wanted the presumption of joint custody. We had some judges, we had some masters. One of the masters, magistrates now, became a judge in, I think, maybe Frederick. Anyway, we had a very large group of people involved, and that were very knowledgeable about this issue. And basically, what happened is that I guess it was last year, the Maryland State Bar decided just deal with the custody decision-making factors that the judges use, because now they are in statute. And a lot of folks, a tremendous amount, and I don't have the figures, represent themselves or initially represent themselves and realize that that custody decision-making is very complicated, and it's that good term, but that very difficult term to define what's in the best interest of the child. And so it is all case law. And at one point when we were talking about this hearing, I suggested to my aide, well, you know what we need? We need to show all the books, that all the different cases that explain what is in the best interest of the child, that are still very valid. Well, we thought about it, and then she said, "Oh, no, we'll Xerox all the case law." And I said, "No, we're going to break our copier." So anyway, we decided we're just going to go with what the state bar suggested. And I'll give you the political history of this. Many years ago, Tony O'Donnell, who was a Republican and also on judiciary as myself, he was able to get the bill out, and it basically was the presumption. It was the presumption of joint custody. The Women's Caucus went absolutely crazy, and one of my colleagues, who I will not name, who became a senator, who now is
Delegate McComas, I'm sorry to interrupt, but are you on the right bill? This is HB 1209, Child Abuse and Neglect Report.
I thought this was the custody bill. I'm sorry,
no.
because I did not.
This is your reports and records.
Oh,
where you reporting
fatalities. Yes. Okay. I am so profoundly sad. Okay. Well, actually, I just listened to a Sheila Cast had the lady that wrote that article for the Banner on, and I was taking copious notes. This is a good bill, and we have tried numerous times to get it passed. It would pass in the Senate. Senator James would have it, and then it would go to the House, and it just languished. And usually it's the other way around. If you want to kill a bill, you kill it in the Senate. You don't kill it in the House. So I listened to this wonderful podcast that they had today at 9:30. And I don't know if I think if you go to Sheila Cast's website on WYPR, you can listen to the reporter that did the information, and it's really fantastic. And we need this bill is a very simple bill. It's a itty bitty bill, but basically we are not complying with federal legislation and the numerous factors of the child abuse and neglect. And this has been going on for years and years. And we have a monitor, and basically there's no sense me talking about it, because the reporter did an excellent job explaining what the problem is. Now, she wasn't focused on just our bill, but the point is the department's not doing the right thing. And then she also, and I'm going to listen to Delegate Shetty's subcommittee hearing with the Department of Human Services. This is a little bill, and I know that Senator James, all right, talked to the State's Attorneys Association, and they came up with that modification, so that if they feel that if there's any way that any information would come out that would harm the prosecution of their case, it would not be released. And we have Child Fatality Group, and then this bill will help aid that, because Delegate Grammer is on the Child Fatality Task Force bill, and he is a member of that committee, of that subcommittee or organization. I think that it's a good bill. I know that the Department of Social Services is under a tremendous amount of pressure. We have the worst fatality records, at least according to this federal report that goes out yearly. We're one of the worst in the United States. We're not helping our kids. we're not helping the children in Baltimore City, and we're not helping the children in foster care or the children that are returned to different family members. Because as I said, a long time ago, we tried to have a hearing on little Sierra Jobes, and she was a little girl that was returned to one of her relatives, and the relative had severe mental health issues, and the little girl starved to death. And then there's a current case now that the little girl, the child starved, and they didn't feed the little girl. But little Sierra Jobes, we wanted to have a hearing on it, and this was a number of years ago, and social services came in and said, no, we can't. Everything's got to be confidential. And I think I understand the issue of confidentiality, but we need to circle back and see what's going on and have a good review of why children that are in custody, either in foster care or returned to the families or relatives, and they don't survive. So I know confidentiality is a very important issue, but we're basically fighting between confidentiality and the life of a child who can't protect themselves. And I think that life of that child deserves some priority. Now, you guys are the ones that can figure this out, but I think this bill should be passed because it's a baby step. And unfortunately, it did not have a cross file this year from Senator James. And so I think that's a concern, but I think that we should pass it and send it back to the Senate, and I think it should pass because I know I listened to the hearings, and I know that Senator oh Lord, I'm having a brain freeze. The chair of JPR thought she did a wonderful job on it. So it's the same bill that got out of the Senate last year and went to the House, and it just languished. And so it's a good bill. So I think if anybody has any questions, let me know. I apologize. I ramble on.
So let me just and I'm not trying to cut you off necessarily, but I just want to make sure that we get a clear understanding of the bill and what it does. And so it's my understanding that when there's a fatality for it looks like, is it for any child abuse, neglect, anything under DHS that it requires the Secretary of Human Services or a director to make sure that they disclose the information within a period of time? Is that how it's formulated to work?
Okay, if you look on page 3, okay, and I'm going back to the original bill, which ours is the same because we double checked it. My aide said they're different, and I said no, they're not, and we got into a anyway.
Yes,
it's on page 3. Okay, on receiving page 3, numeral 3. Okay, 1 on receiving, and this is on line. Well, it doesn't. I apologize. I thought we were doing the other bill, so I apologize. Anyway, let me see if I got. Oh, and of course I didn't print that one out because I used it online. Anyway, the bottom line is they're not the SB 89, which was last year and passed. It's a little bit different as far as the setup, but it's the same thing because my aide and I went literally.
So because the other thing I do have a copy of is the amendment for SB 89. So
Okay.
are you going to offer that as an amendment?
Madam Chair, let me explain this. I don't think it's necessary because it's already in the bill, and it may be the way of drafting because my aide and I were both lawyers, and you get 2 lawyers in a room, you can't get any consensus. So I said, no, it is in there because the fact that SB 89 did not pass, it's going to look differently than our bill because of the way they do the drafting. But the information is in that bill.
No, I think the exact language is in the bill, as a matter of fact, if I'm looking at it correctly. So that's why I was asking you, because it is in the bill. The language that you've mentioned is in the bill. And I don't know, Lauren, if you have it handy and you can just later on just
Madam Chair, when you're done, can I ask a question?
Yes, as soon as I'm finished, Delegate Kaufman, I see your hand.
I didn't know if you saw it.
Yeah, I saw it. I got you. Yeah. Yeah, Lauren, if you can at some point just double check it for me. But I think the language is in there, Delegate McComas, that is in this amendment. That's why I wanted to make sure we're looking at everything we need to regarding the.
Madam Chair, may I just say one thing? When my aide said, "Oh, it's not the right bill," blah 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 blah. It's not. We don't have the amendment in there.
Mhm.
I wrote everything up the minute she said that, and I took it down to the committee, and then my aide and I we went through it and everything, and I said, no, it's in there. So then I told the lady at the desk, I said, just tell Lauren it's all good. But I want Lauren to check it over. But I just didn't want to, because you guys have long days, and I thought we were good. But if Lauren wants to check it, that's the.
Yeah, I just would like for her to double. I mean,
Oh,
like I said,
I'm all for it.
Yeah, my first blush reading, it looks like it's in there. But anyway, I just want to double check. Do you know what the federal factors are dealing with child fatalities? Because
Actually, I think you have someone on this call that is probably much more of an expert than I am, and I'm not sure they don't want to say anything. So, one of your colleagues.
no, but I mean, if you don't have it, that's fine. 'Cause we
I
can get
don't.
it. I'm
I
just.
don't.
Okay.
I will, if you wish, and you want precisely what you want, I will go to the library and get it for you.
No. I'm just asking because you said the basis of your bill is dealing with the federal factors. So that's why
we're
I
not.
was asking.
Yes.
Okay.
Yeah.
All right. So I'm going to go to the questions from the subcommittee. Delegate Kaufman, you had a question?
Yes, I do. And Delegate McComas, I really appreciate your passion and your not vast knowledge about this. But it's still not clear to me after listening to you. I think I get it from reading the summary in the on the General Assembly website. Um, um, but could you please just say, and only this, like what your bill does? I think it's about turning over fatality reports to a state's attorney. I mean, I appreciated the history lesson and your passion, but I really need to know what the bill does.
What the bill does is it provides accountability of the Department of Social Services and the system that when there is a fatality or a severe abuse of a child, which is either in foster care or in loco parentis, that the ultimate parent is the state of Maryland, that there should be accountability. And it seems like if a child is severely abused or neglected or dead, there should be some kind of accountability. So we know how well our Department of Human Resources is doing. And it's a real simple bill. Other states have much more metrics. That's why I think if you listen to this, and I know everybody's busy, the interview that Sheila Cast had with the reporter from the Banner, I think you'll get a really good capsule of it. There's a lot of
Delegate McComas.
So all this does.
Delegate McComas.
Yes,
Delegate McComas. Let me just kind of follow up and talk a little bit to Delegate Kaufman's question, which is, what does the bill do? The bill is a bill designed to provide reporting. Is that correct? From
that is correct.
Okay, and it's reporting to who? Who is DHS going to
what it does is okay, the state's attorney is given 30 days when there's a request for the information and whether any of the information in the report should be redacted so that does not harm any prosecution of whoever was complicit in the death or fatality or severe injury of the child.
Okay, so let's stop there. So the report from DHS, right? Whenever there's a fatality for a child, for child neglect, child abuse, right? They are sending a report to the local state's attorney for that particular county or city. Is that correct?
All right, let's go back.
Uh-huh.
All right.
Would it be helpful if I give it just a quick overview?
Yes, Lauren, that'd be great. Thank you.
Okay, so this bill is really concerning the required disclosure of child abuse and neglect records when there's been a fatality or a near fatality of a child who was in the custody of a local or state department or agency or in the care of a foster parent or is the subject of a report or complaint received by the local DSS, for example. And currently, for this information to be disclosed, the state's attorney has to advise DHS that disclosure would not jeopardize or prejudice a related investigation. And essentially what this bill is doing is just shifting that. The biggest thing it does is it's shifting the required disclosure by saying that now the state's attorney gets not just, but the state's attorney essentially now has a chance to redact information that would seriously hinder prosecution rather than before where it was they could sort of block disclosure by saying it would jeopardize or prejudice an investigation. Well, it's essentially making it, I would say, easier to release this information.
Okay.
Um,
And so who typically is requesting the information?
I mean, this could be the press, this could be to
Okay.
make it public, for example.
Okay.
Or it could even be a legislator that is very concerned about the health and welfare of children that are in the system that are abused or killed.
And they have 30 days to disclose this information, right?
Thank you, Madam Chair, for your
Yes, that's
indulgence.
right.
Thank you, Madam Chair, for your indulgence and committee for your indulgence. I just needed to know what the bill did before I voted up or down. So I thank you
Yep.
for.
Absolutely. All right, Delegate Valentine, you have a question as well.
Madam Chair, you just asked my question. Who was asking and not receiving the information? Thank you.
Okay. All right, are there any other questions?
Yes, Madam Chair.
Yes.
Delegate Temple Hughes, I think my hand blends into my background. But what I wanted to just understand is if the department sends the information to the state's attorney, they have that 30-day window. What happens if they don't abide by this 30-day window? To whom does it harm? What is the problem at the end of the day? And Lauren or Delegate McComas may have the answer. And I think go ahead, I'm sorry.
Lauren, are you able to help us on that one?
I'm not sure it's harming, but it's giving the state's attorney this chance, and they need to notify under law, they need to notify the local director or the secretary within 10 days after conclusion of the investigation, and then within 30 days of notification from the state's attorney, the local director shall disclose. I mean, I don't know, there's no criminal, I guess if you're asking, there's no sort of civil or criminal penalties embedded in the bill. It's just sort of like any other law. It's a requirement stated in the law to follow.
I guess I'm just missing the part about the benefit of it at all.
Right, of the bill itself is what you're saying.
Yeah, I'm just trying to understand. The sensitivity of the information and the necessity to make sure everybody's covered. I get that, but I'm just not understanding once the state's attorney's office does their part, what are we gaining at the end of the day? Or has it been harming cases?
So maybe we should start with what again, which is your question, is what does this really solve, right? So what is currently happening? Does Lauren, do you know what currently happens right now with child fatalities? Or
currently, this information it has a stricter standard for disclosure in that so under current law, this is already in place. There's already a statute for requiring this disclosure, and there are limits. I mean, that certain things can't be disclosed, certain protections are in place. And this is sort of, as I was mentioning, this is really shifting before the state's attorney could, I would say, block the disclosure by saying, okay, this would jeopardize or prejudice a related investigation. Now this is saying it must be disclosed, but it gives the state's attorney a chance to redact information that the state's attorney finds would seriously hinder prosecution. So this is already in place. It's already going to be disclosed. It's a matter of what the standard is. And I think the background, not arguing for or against the bill, this is an accountability bill. It's like telling the public in cases where a child, for example, the public or legislators, like Delegate McComas said, in the case of a fatality or near fatality, it's sort of mentioning that maybe there was a failing at the department level that somebody wants to look into. So it's a sort of that type of bill.
Okay. All right. Delegate Simpson, you have a question as well?
Yeah. So my issue previously with this bill, and as you know, my background is in child welfare. I agree that it is very alarming, the number of deaths that have occurred. The problem I have with this bill, and I had it with last year, is that it is open to literally anyone. So if somebody just wants to know, and it would end up requiring, could get their name and everything else. I mean, and I don't think that's appropriate. I think that children deserve a lot more privacy than that. That was my concern last year. I do appreciate it seems to be modified so that the state's attorney can block it. Because I also said, you know, you could get this information, the person who is the perpetrator, so that they can develop their case or whatever. I think there's too many holes in here. I don't think it's ready for prime time. I understand the reason for it. I think the problem with Maryland in general is that in the 90s, we passed the laws about citizens review panels, and they've kind of been defunct because that was also a kind of a regulatory looking at these cases. So we are leaning so heavily right now into the fatality review teams, which of course they're not really looking at near fatalities. They are looking at fatalities, which is a little too late. I do think that we need a greater look at our Department of Human Services. I do believe I fully support and hug Delegate McComas on the goal of this, but I would prefer to see a work group with the judiciary, with the Attorney General, and come up with something that obviously is going to serve the purpose of the bill, which is to make sure that there is actual disclosure and that there is actually some accountability without harming families and children who are caught up in the system. And I do not think this bill has any of those safeguards.
Okay.
And those are my concerns, which isn't that so? Oh.
All right. Anybody else have any other questions, concerns, thoughts on the bill? Okay, what I think I would like to do is to table this bill for another meeting and invite in the Maryland States Attorneys Association, DHS, and possibly the judiciary to talk to us a little bit more about this bill, what it does, and how its procedure and process will be. Okay. So thank you very much, Delegate McComas. We will be inviting you again to another subcommittee meeting once we have the other folks we'd like to talk to as well. So thank you.
Thank you.
Right, great. All right, so our final bill, and this final bill is really for us to start discussion on because it is a long bill. As you know, we went through the hearing on last Thursday, and that is HB 218. So there should be a couple of people, I think, from DHS in the room. So do you want to go ahead and invite them in if they are waiting in the waiting room? And if not, just let me know.
Madam Chair, can I leave or?
Yes, ma'am, you may.
Okay.
You may.
All right. Thank you all.
Absolutely.
And I think
Thank
it's
you.
an excellent idea because it's a complicated issue and I think maybe a task force because it is your bill.
Yes,
once
it
it goes
is.
to you guys, it's your bill. But
Yes.
I think we
Thank
gotta do
you.
something.
Thank you, Delegate McComas. All right. So I just wanted to again start out discussion on HB 218. Like I said, it's a long bill. We're not gonna in the next 15 minutes get through it, but I know there were some specific concerns with it. And I just want to kind of start out with a general overview if we can. And I see who's here from DHS, Melissa Bender, you're here, and Justin Hayes.
Yes, Madam Chair, this is Justin Hayes. I serve as the Deputy Director of the Office of Government Affairs for DHS.
Okay.
And with me also is Jarnis Johnson, the Executive Director of the Child Support Administration.
Okay, great. All right. So with that in mind, what I'd like to do is maybe just talk about the big points or areas within the bill itself. And I know that child support arrearage was one of those areas, because I want to make sure the subcommittee kind of understands how, what the thought process was behind bringing in the arrearage sections. So if you want to start out with just talking first of all about the MVA, child support arrearage section, and then we'll talk about some of the other sections that if we can get to them.
Okay, well, the intention of the bill would be to exempt non-custodial parents who are at or below 250% of the federal poverty line from suspension of their driver's licenses for non-compliance with the child support order. So that is one of the foundational pieces in this bill. I'm not sure if there's a specific question as to how the arrears portion factors in, but I think Jarnis might be able to explain that a little bit better than I.
Yes, that'd be great. Go ahead, Ms. Johnson, if you want to.
Subcommittee, thank you for inviting us today to speak with you and to answer any questions that you may have. As Mr. Hayes had already identified and laid out, that yes, the intent of the driver's license suspension bill is to not include those individuals in the suspension of the driver's license if they are below or at 250% of the poverty level. The bill would allow the non-custodial parent to receive notice in order to provide information to the administration regarding his or her income. And we would run the figures or do the calculations to determine whether or not they meet the qualifications. Also, one of the amendments to our bill is to extend the time frame from 60 to 120 days before they would be eligible for the suspension. So as far as the arrears are concerned, this would also give a non-custodial parent an opportunity to provide his or her income information so that we may look to see whether or not they meet the guidelines or the qualifications for a modification. Because they could have had a child support order that was issued 10 years ago. And if they're not able to pay the full support, those arrears continue to accrue, regardless of whether or not they would meet the exclusion for the 250 under the 250% of the federal poverty level for the driver's license support program. So what we would want to do is to engage with those non-custodial parents so that we can look at their income information, not just for the driver's license suspension program, but to right size their order. That's part of what we consider the arrears management piece of this, is the engagement to determine whether or not they currently have the ability to pay or not have the ability to pay. So that's where the arrears come in with this, so that we can get appropriate income information, because it could have been 10 years ago that they had a child support order issue. And of course, as we know, circumstances change, things change. So did that answer your question?
Yeah, so that's part of it. So what I want to do is take bites of this to kind of explain it, because it's such a big bill. So does anybody have questions about this specific section that we just spoke about, or Ms. Johnson just spoke about? Go ahead, Delegate Valentine.
Thank you, Madam Chair. I did have a question about, I guess it would be the child support orders themselves. Aren't there, like, you mentioned 10 years. Can't someone have a motion for I forget what the terminology is, but to reevaluate their orders now, or on some type of a schedule now, like every so many years?
Yes, they can. We send out notification to both parents that they are entitled to receive a review of their order every 3 years.
Okay.
But not everyone takes advantage of that right to review. And if there have been no changes at that 3-year mark, then the order remains the same. So the reason I say it could have been 10 years ago, because maybe at the 3-year mark, there wasn't a change in circumstances. But the following year or next year, there could have been. So yes, that is in place. Currently, we do offer that service.
But is that 3 years and then you're done, or is it 3 years and then it could come back around again in 3 years? So
It's
could it
every
happen
3
multiple
years.
times? Okay, every 3 years.
Yes.
Okay.
But it's up to the parent to take that opportunity.
Okay. Understood. Thank you.
Yes, you're welcome.
Okay. Anybody have any other questions about this particular section? Okay. All right. Then, if you could talk to us a little bit about the independent contractor section as well.
I will start off by asking, is there a particular question or are there?
Yeah, if you could do an overview, because what I'm trying to do is make sure the subcommittee understands the pieces of the puzzle here, because it is a big puzzle. So I wanted to make sure people understand what this bill does, because there's so many different sections that we're tackling child support.
Madam
So
Chair,
if you
I'm
can do an
happy to jump
overview.
in with just a quick overview.
Sure.
Very simply, the legislation would require the Department of Labor to include 1099 independent contractor employees in the new hire reporting that comes to the Child Support Administration. This matches what already exists for W-2 employees and just gives us access to that same information for 1099 independent contractors.
Okay. Okay, does anybody have any questions about that? Okay, Delegate Simpson.
Just the backup on the other issue, I would just think if we want to talk about the piece about the 250%, I would like to have Delegate Tolles to be, because I do know that she has her bill and she has a history with it. So I would, I mean, I'm not an expert in that area, so I would really, if we can revisit that with her.
We will get to that, Delegate Simpson.
Yeah.
This is not the end, okay? This is just for the subcommittee. I wanted to make sure the subcommittee had an overview of the bill, okay? And
then I guess with the contract, so going with the contractual, can they explain how that would the work? This is the 1099, right? Is that what we're?
Yes, that is
like
what we're talking about.
Give us an example of how this is going to work for a private contractor, and what the burden. What I'm hearing from people is the burden on the employers who are contracting with them. They're not actually, that's not their employee. Does that make sense? Did I make that clear?
I think so.
I think you did, yes. And if I could, I will attempt to answer that question to the best that I possibly can. What this bill attempts to do is to just bring it in line under the new hire reporting. Under the new hire reporting, our employers are already required to report under the statute those newly hired individuals. What this bill would also do is to include the independent contractors in this requirement. And I did a little bit of research this morning, and if that employer is already reporting this individual, these earnings or the amount that they're paying to the feds, they are required to submit or turn in a 1099 so that that employee is what they'll be called, I'm assuming, can file the 1099. But I believe, if I'm not mistaken, if they pay someone $600 per year, and they are submitting that information to the IRS, they are required to also provide a 1099 form for the employee. So it's just bringing them in line with what the requirement is now, that they are required to report an employee to new hire reporting. So if they are giving a 1099 because they are reporting these earnings, then that will just bring them in line with the new hire reporting that is already in law today.
Okay. Any other questions? Okay. you also have extended the contempt from 3 years to 7 years. Can you talk a little bit about that to us?
Yes, the extension, is to allow the custodial parent to receive the support or to allow, other recourses or, let me back up because I want to sort of explain it a little bit so that, it's not so confusing.
Yes.
Right now, when the child emancipates, under this current statute of limitations, we cannot take that case into court if the child has emancipated 3 years or more. So we are not allowed to assist the custodial parent who's already asked for child support services and using additional resources that we may have available because the statute of limitations run out at 3 years after the child has emancipated. Extending it to 7 years does also give us an opportunity to work with the individual and not make it so burdensome on the custodial parent to have to file a motion with the court to reduce the arrears to judgment and hire legal representation to go into court to collect those arrears if the administration is not able to collect because the person could be self-employed and we don't have the income information, or the person, we cannot use any other tools in our advantage because there's no bank account. There are no other resources that we would be able to tap into to get those collections for that parent. So therefore, there's nothing administratively that we can do once that child has emancipated 3 years. If it's been 3 years since the child has emancipated. So it just extends it to the 7 years to allow us to assist that custodial parent in collecting the support that has accrued and was not paid when the child was a minor. That's all it does.
Okay. Any questions regarding this section? Okay. All right. And again, we're just going through a high level overview right now. Then there is a section that deals with winnings, meaning, you know, any sports wagering winnings, fantasy winnings, any of that can now be, I think that now can be certified and taken as a part of child support arrearage. Can you talk a little bit to that, please?
Sure. At a very high level, this just brings the sports wagering in line with the existing law that allows us to intercept casino and lottery winnings. And as you know, fantasy and horse racing and sports wagering, it's becoming quite big in Maryland. And this is just another resource pool that would allow us to get the support to the child, similar to the casino and lottery. The non-custodial parent has to be in arrears of at least $150 or more. And the winnings have to be about, I think it was $600 in order for us to be able to intercept those winnings. So it won't be a burden on the smaller businesses. Say, for instance, if someone wins $100 or $200, they don't have to report those. So it's only $600 and above as far as the winnings. But
You get those at 11s and those other.
Right now?
Yeah.
Can someone turn off can someone mute? Okay. Go ahead, Ms. Johnson.
Yeah, I was just gonna say, it just brings it in line with the other, the lottery and casino winnings that Maryland has already enforces or intercepts those payments. So
Okay.
it's just an additional payment resource for those custodial parents and children to be able to get the support to those families.
Are there any questions on that? Yes, go ahead, Delegate Sample Hughes.
Thank you. With this additional effort to garner funds, does this bring any additional burden or efforts to your department? Does that require another level of process, more staff, or what would that entail? Because I'm not really honestly familiar about how you go about getting the information now. And so I'd just like to know how that process works real briefly. Thank you.
Sure. It's no additional resources needed as far as staffing is concerned. This will be an automated match with the sports wagering agency. I'm trying to remember what the agency is called, but anytime someone, it's like a certification. It's like we certify the arrears or the non-custodial parents' information to the lottery, as well as for casino winnings. So when they go in to turn in or to accept their winnings, that information is put into their database. And we send that information to the lottery and the casino. And if it comes up, and I think they do report through the lottery commission. So I think that's what it is. So the interface is through the lottery commission. And if they enter the information, it comes up and then they withhold those funds. Now, they will notify them, however, that they do have a right to appeal the intercept of those winnings. So, and they have a certain time frame to appeal that with the Child Support Administration, and we will review that, and then we will determine whether or not the arrears, because there is a basis for the appeal, and that's what we would do. And we also have spoken to the State Gaming and Lottery Commission about this. So we're all on board with it, but it's no additional resources that are needed on the state side.
Okay, just one more question. So if you are the one who is getting the winnings and you're immediately notified that you won't be able to get all of your winnings, so you're able to make an appeal right then and there, and then the casino says, we won't give you any money at this time? Or are they able to give something and then you appeal? What's that?
What they will do is they will withhold the issuance of the winnings. They will notify or inform the non-custodial parent. And I think they will give them a form, and all of those particulars will be worked out during the implementation as well. And they will tell them where they need to go to request the appeal and how they will request the appeal and the time frame by which they would have to request the appeal. I believe what I read was the 15-day appeal period. So those due processes are built into the law to allow a person to contest or appeal their winnings. But the Lottery Commission will withhold. They will not disperse the funds if there is an arrearage for that individual claiming those winnings.
Okay, thank you. Because we have another bill. It's not with, I don't know if it's in this committee or not, but it deals with expanding the opportunity for being on your mobile device and doing more gaming.
iGaming.
Curious,
iGaming bill.
I was just curious how all of this even comes together, but thank you for the explanation.
Sure, no problem.
Okay, any other questions, thoughts, ideas? Okay. So what we're going to do is we are going to go ahead and adjourn, because as promised, I'm trying to keep these to 1-hour meetings because I know everybody's got busy schedules. So what we will do is we will probably invite you again to give us more information. And just again, we appreciate you being here to provide what you did. And to the subcommittee, we will meet again. So thank you very much, everybody. Appreciate you being here. And do I have a motion to adjourn the meeting?
So moved.
All right. And a quick second, please.
And I just wanted to say, Delegate Crutchfield, thank
Yes.
you for the opportunity to come before the subcommittee to answer your questions. I am available anytime that you have any additional questions. Please call on me, because what we do want to do is to make sure that everything is understood and that we will answer your questions to the very best of our abilities. So I would like to say thank you for the invitation, and we will talk again soon.
Great. Thank you so much.
Thank
All right.
you.
The meeting
Bye.
is adjourned. Thanks,
Yes.
everybody.